So I don't want to live with my landlord or spend the nights with my landlord and his family.
I am not aware of any law that would say that an owner cannot access property that he owns simply because he has leased a portion of that property to someone else. As I understand it, I think I understand the issue here to be that Mr. Johnson owns a condo unit on 17th Street, and I think it's a two-bedroom condo, and that Mr. Johnson had allegedly, according to the petition, had leased a portion of that unit to Mr. Brooks. Um, and then perhaps there was some realization that that was not allowed under the rules of the condo association. And that's where I sort of lose the narrative thread, right? So I think what I understand is that once Mr. Johnson learned that he tried to make some changes to the lease agreement with Mr. Brooks. But the lease isn't actually attached, so I don't know what the lease says or what obligations Mr. Johnson agreed to, gave to Mr. Brooks, and so that's sort of where I'm left off in terms of understanding the issues. Mr. Brooks, you filed the action and it's your motion, so I'm going to let you start by sort of outlining what your concerns are. And if you could start by telling me, if you have a copy of the lease, and sort of what your understanding of what you were agreeing to get in the lease. And then there's a reference in your TRO petition to some changes that were made, allegedly without your permission or something like that. If you can sort of start with that.
Okay. Good morning, and thank
Good
you
morning.
for allowing me to appear before you today. So I entered into a lease with Duncan Johnson. He is the owner of the condo that I rent. And it was my understanding when I signed the lease that I was renting the master bedroom in that unit. And there was another tenant who was also renting the second bedroom. So the agreement that I entered was a tenant occupied agreement, realizing that I would be in the master and the other tenant would be in the second bedroom of this two-bedroom townhome. Nowhere in the lease does it designate that this is an owner occupied unit. No, and one of my main concerns was the owner has frequently um, acted in such a way where he um, is acting as if he has the right to stay overnight, to appear in the townhome over the holidays and spend the night with his entire family, that sort of thing.
Well, let me ask you a question. So, Mr. Brooks, I mean, I understand that, and I can imagine that that is quite disruptive, right,
Very
in terms of
much.
what you're expecting. But I guess because one, I don't have a copy of your lease, right? But if your lease at its most basic says you have access, that you are leasing the master bedroom and then some portion of the common areas, right?
Mhm.
Then unless there's something in the lease that says Mr. Johnson can't be there, why wouldn't Mr. Johnson be able to be there in the spaces that you're not renting? Because he's the owner. That's what I'm struggling to understand.
Well, my understanding is as a landlord, tenants have the exclusive rights, and there is nowhere in the lease where he has reserved any space of any part of that unit to himself. I don't have a problem with Mr. Johnson being the owner, and perhaps if he needs to come in, if it was allowed to rent that second bedroom, to show the second bedroom, to come in for inspections. But his entry, the way he has been entering, to me is unlawful, and it invades on my peaceful enjoyment rights as a tenant. I do understand that I did lease the master bedroom, and I'd also have access to the common area. So any other area in that unit outside of that second bedroom, I have rights that I should not have to ever share with the landlord. And the landlord does not have any occupancy rights indicated in the lease.
Well, and so
And
that's
so,
so Mr.
uh,
Brooks, do you have a
mhm,
copy of the lease? Because so I don't have a copy of the lease. It wasn't attached to your filing. Um
I I
and
have
and
up.
here's why I asked,
Mhm.
because if the lease says something about the owner not having any disclaims any right to possession or anything like that, then that would be one thing. But I'm not aware of any law like what you're referring to that if I am an owner and I lease a portion of my property to somebody, that I'm somehow giving away my right to be in the spaces that I haven't leased to you. And so it would be helpful to me. Are you able to forward that by email, perhaps to Mr. Freehoff, so I can see it?
Yes, I am.
Okay.
Um, so it's actually on file with the courts in the pending um, dispossessory, and I thought that that would be sufficient. But let me pull it. I do have a copy saved to my phone.
So
Give
if you
me.
have the case number for the dispossessory, I can find it, but it's not linked
Okay,
as
and I
a
can and I and I can
it's
tell
not
you
linked as a
the
correlated.
case number for.
Yes, sir.
Okay. Okay, so the case number for the dispossessory that is pending and to be heard on February the 11th is 26 E as in Edward, D as in dog, 374875. Duncan Johnson versus Whitney Brooks.
Okay.
Okay.
Thank you. Please continue with your presentation. While you're doing that, I'm able to pull that up and see if I can see it in the system. So,
Okay. And so my understanding of the exclusive tenancy rights is not saying that I have exclusive possession and of the entire unit when there's another tenant there, but I'm not sharing it with the landlord because that's not in the lease. And so um, I complained about that. One of the things I want to back up, there was some other things that I needed to clarify. So there is provisions on the landlord's leasing permit that prohibit him from fractionally leasing the condo. I was not aware of that. I was not aware that he was not allowed to rent the master bedroom to me um, in a fraction and to rent the second bedroom to the grad student who was there until circa December 1st. She's gone now. I'm the only person in the unit now. When that issue came about, Duncan made some unilateral changes to the lease using the original signature from my lease that was signed on November 26th because there were some terms in the lease. I'm sorry, there are some terms in the HOA um, guidance, bylaws, regulations that were listed in the leasing permit that were required to be a part of my lease. In addition to that, Duncan was responsible for providing me with copies of the bylaws, covenants, and the rules of the HOA. When he did none of that, in the oversight that the condo management has over the lease, they had issues with how this lease was structured, what this lease did not include per the leasing permit that he agreed to. And long story short, they're not allowing, as long as my tenancy is in place and they are not trying to evict me. I had to confirm that because Duncan alleged that they wanted him to evict me. And when I followed up directly with them, That is not what they're saying to me. They are penalizing Duncan for being out of compliance, not following the rules of his leasing permit and the HOA requirements in terms of the documentation that was required on the lease. Now, what he did unilaterally, when he added my name, I immediately stopped him. And he then continued to try to get me to sign his addendum. But because of all that he had already done, including, well, this is not something that I was involved with, but what I was told, this is hearsay, the leasing, I'm sorry, not the leasing, the condo management told me that the grad student was added under my name as a family member, and she was never a part of my lease whatsoever. So they were thinking she was my family member. And one day when I was having some type of badge issues, they asked me about my family member. And I was like, what are you talking about? And then that's how that came out, that Duncan allegedly reported to them that this lady from Spain was a family member. And I clarified that she's not my family member. And in fact, she physically moved in before I did. And although I may have signed the lease around the same time, her physical presence and coming into the unit was before mine. And so all of this, the details of what was required in the lease came out. And as a result of the non-compliance, my landlord was being fined to the point where some of my access levels were turned off because of his being behind on the fees and all that stuff. They eventually turned all that stuff back on to support me, and did told me that they were not seeking my removal as long as no one else moved into that unit, because only one person can lease that unit, or one unit, like a family unit, married couple, or family with children, that sort of thing, but not this person rents this bedroom, this person rents that bedroom, and another person rents the laundry room. Can't happen.
I'm
and so
familiar.
and the bylaws and the rules override what he didn't put in the rent, in the lease, per the leasing permit. And so because of that, and he also, his
Well,
possession.
forgive me,
Okay.
Mr. Brooks, let me interrupt you, because what
Okay.
I understood your primary complaint to be, I understand there's these larger issues, but
Okay.
respectfully, those are probably part of the dispossessory action and not really properly before me. But what I
Okay.
understood your primary issue to be is that Mr. Johnson was continuing to access the property and to be in the space with you.
He
Is that
mhm.
correct?
That is correct. And not only is he doing it, he is sending people who are not parties to the lease with keys, and they are doing it as well. And he opens the door as if he lives there, and fails to coordinate or have, I don't have a problem with my land. In every place that I've ever lived, landlords have always had rights and access, and that's not a problem. What is a problem for me is for me to come into my home on Christmas Eve and find my landlord and his entire family in the kitchen cooking. What I have a problem with is me hearing the door unlock with a key and no one has even knocked, and the door opens and it's someone I don't know. What I have a problem with is the landlord sending his wife, who is not a party of the lease, she using a key and coming in and interrupting me as I am actively participating in an interview with my company. And those sort of things, for me, are, invading in my rights to peaceful enjoyment. I did not enter in a landlord occupied lease under no circumstances. And so I don't want to live with my landlord or spend the nights with my landlord and his family.
So,
And
Mr. Brooks,
yes.
forgive me, but let me
Mhm.
ask you a couple of questions, and then I'm going to
Okay.
hear for Mr. Johnson.
Okay.
So I've had a chance to just very briefly review the lease that you attached to one of your filings in the dispossessory action.
Mm-hmm.
it, I think I understand, and I want to clarify that your position about the landlord not having any rights to access the property, that is something you understand to be a part of just sort of Georgia law, and not necessarily that there's a particular provision in that lease. Is that correct? Or if there is a provision in that lease that you believe says the landlord can't be in the house, can you point me to that provision?
My understanding of Georgia law is that when I sign the lease, that gives me the possession. And according to the bylaws of the HOA, which override this lease,
Yes,
the
but you're not a
possession
party to
is
the
not as
HOA. Right, Mr. Brooks. So that's
right.
that's part of the issue. You're not a party to the HOA. And so
Mhm.
Mr. Johnson
But
may
I'm be,
be while Mr. Johnson may be in trouble in violation of the HOA requirements, and while you're right that the HOA requirements trump what the individual homeowners, condo owners, unit owners can do with their property, I'm not sure that you, as a tenant, are allowed to assert those HOA rules and requirements against an owner because you're not actually a party to that. I mean, the reason those condo declaration rules apply to Mr.
mhm.
Johnson is because he is in a contract with the HOA or the COA, and he is governed by the declaration, which are the rules and requirements that you're referencing. But you're not a party to those, so I'm not exactly sure that you have the ability to access that. And I'm also not familiar with. I'm not familiar with. Certainly, I am familiar with Georgia tenancy laws that say that if a landlord rents a property, that they have to be reasonable about their access to the property, right? So if you
Mhm.
rent an entire condo from a landlord, then you would, I agree with you, expect that that landlord's not coming in, et cetera. But when you're talking about the exclusive use and enjoyment, assuming for a moment that that applies here, what you're being given is use and enjoyment of the space that you rented. And so, unless you're going to tell me that Mr. Johnson or his family came into the master bedroom,
Let
right?
me
And so, that's so far, that's what I've heard. I'm also very concerned about the fact that this dispossessory action exists because I suspect that that means that this really should be handled in the dispossessory case. But setting that aside, Mr. Brooks, what I'm going to ask you is to sort of give you a couple of minutes to sort of, you will get another chance to respond to anything that Mr. Johnson says. Um,
okay.
but I want to give you just a couple of minutes to finish sort of telling me what it is you want to tell me, understanding that what I need you to focus on is the relief that you've asked for today is that I enter a restraining order saying that Mr. Johnson may not access the condo unit that he owns.
Mm,
Um, and so,
That's not what I'm asking.
okay, what are you asking?
No, for unlawful purposes is what I'm saying. I'm not asking. It's reasonable for him to have access. If there's repairs that need to happen, if there are if he chooses as a landlord, I want to come in and I need to change the filters, or I want to inspect just to make sure there's no leaks, that sort of thing. I
Right,
definitely
but
understand
Mr.
that.
Brooks, what I was saying is you haven't actually pointed me to any authority that says that Mr. Johnson isn't allowed to access the portions of the property that are not rented to you. Right.
Okay,
So,
and my understanding of that is I'm not saying that. First of all, I'm not saying that he doesn't have the right to do that,
mhm.
but to use it as an occupant is my claim and my understanding of Georgia law. Of course, if he's coming in, he's changing furniture out, he's making repairs, he's vacuuming, he's cleaning, he's painting, he's getting it ready for the next tenant. Yes, but there is not an agreement between us, and this is an agreement in its entirety. This lease for him and I has an entirety clause. And there is nowhere in this lease that tells me, and even if it's ambiguous, to me, that should not penalize me. There is nothing in that lease that tells me at any point that I will be residing with my landlord and his family, and that people who are not parties to the lease, like his wife, who is not listed on the lease, has keys to the unit and can come and just take a nap and spend 5 hours in the unit. And anybody that he desires to give a key to can just come and unlock the door and come into the unit. That violates safety for me. It violates peaceful enjoyment for me. And I'm asserting those rights. Reasonable landlord use, reasonable landlord access. I've lived in another home that Mr. Johnson owned and successfully finished that time there. And I had not these same issues in that home as I'm having in this. I'm basically asking for that boundary where he's the landlord and I'm the tenant. And really, I don't want to have to continue to see him as frequently as I did. And I don't think, under no circumstances, that the law allows him as the landlord. I have access to the shared space, and I could be walking around because I'm not in there by myself. I am in there by myself completely with just my underwear on. And then all of a sudden the door opens and it's him. That is not what a tenant expects. And my safety, my peaceful enjoyment. I also don't like to be startled with him emerging from a room and I don't even know he's in the house.
Right.
To me, that violates.
I apologize,
Yes.
Mr. Brooks, but
Okay.
I am on a relatively tight schedule. And so
Okay.
I do need to take a moment to hear from Mr. Johnson. And then because it's your motion, I will let you have the last word to respond to anything that
Thank
Mr.
you.
Johnson shares with me. Mr.
Okay.
Johnson, it's your turn, sir.
Thank you, Your Honor. Your Honor, I am appearing specially, and I object to this proceeding due to lack of proper service. I've not been formally served, so at this moment I do not have the full TRO, the complaint, or the detail being talked about. So at this moment, I'm just going to wait for proper service, and then after that, Your Honor, I will respectfully also request 2 to 3 weeks after I'm formally served so that I can seek
So
counsel.
hang on. Let me interrupt you, Mr. Johnson, and just make sure you understand what this proceeding is, right? So Mr. Brooks has the right to come to the court and ask for an ex parte TRO hearing. And if the court, which means you wouldn't even know about it. And if the court determined that relief was appropriate, then you would get notice of that order. And then the court would have to have another hearing where it had an opportunity to hear from you. And so the general practice in Fulton County is that instead of going through that additional process where the other side really doesn't have any notice, even in circumstances where there has not been formal service of process yet, we require that the party seeking the injunctive relief provide notice of some sort, not formal service of process, but at least notice. And you are here indicating that you did get notice. Now, that doesn't waive your right to have formal and proper service of process. And so I just want, and when Mr. Brooks properly serves you with this action, you will have, under Georgia law, 30 days from the date that you are served to file an answer or other response. So I just wanted to address that concern for you so you would understand why we're here, even though you haven't formally been served. And the court does note that your appearance here is specially and that you are not waiving your right to proper informal service. Go ahead, Mr. Johnson.
Thank you, Your Honor. I appreciate you explaining the detail to me. and I look forward to be served. At this moment, I respectfully decline not to discuss anything further concerning the hearing because I do not have the full detail of the TRA and the complaint.
Understood,
Thank
Mr.
you.
Johnson.
Thank you, Your Honor.
Thank you. Mr. Brooks?
Okay. And I would like to add that Mr. Johnson has included in our lease that any matters relating to the lease be sent to the email address, which that's what I did, and also to the address of the condo that I live in. He does not live there. He is actually impeding service because he doesn't live there. And I don't have a physical address where he lives. And so I explained this to the clerk when I filed. And I also spoke with your staff assistant regarding, and he gave me the instructions to, take diligent efforts to make sure that he's aware of the hearing. And that is what I did. I've actually sent it to him like 3 times, including this morning, right before it started, just to make sure, because I never heard back from him on the hearing. And so I'm glad that he did show up and that we are here. But just to let you know that I don't have a service address that I can rely on. And also, based off of his access and the way that he has been coming and going, I'm not even sure if he serves against me that he won't interfere with that, because he could technically file something against me, and then it could be posted to the door and I would never see it. That was my concern because of how he occupies and how he comes in and the way this is currently playing out. And so I was proactive. I went actually to the magistrate court to file against him. And then I learned he's already filed dispossessory against me twice in January alone. And the second one, when I found out that it had actually been filed, I was actually going in to file against him for these matters that I'm talking about, and to also talk about some of the things that he alleged in the first dispossessory that were totally not true and sworn to. And so all of his action, and I really do my honest assessment of what has been happening, because he has offered me an option to terminate my lease early. He's offered me an opportunity to get 1 month's rent plus $500 in order for me to terminate early because of the fines and the things that are happening with the HOA. I chose not to do it because I'm not in the financial circumstances right now to independently take all that on again, seeming that I just did it in September. And so I turned it down. I gave him a counter in terms of what I would take, first and last, plus the 500 moving, but he declined it. And so because of that, I haven't signed any addendums and I haven't agreed to terminate my lease early. I've paid my rent on time early every month since the whole over a year that I've been doing business with Mr. Johnson. I lived somewhere else that he owned, and now I've been in this place since September. I'm not a holdover tenant. I've paid on time, and in my opinion, this lease doesn't, I haven't violated anything in this lease. And so to be facing eviction now because he's not getting his way, or I don't know why I'm doing it. He says I'm in breach, but I don't know what I'm in breach of. And me asserting my rights are based off of my understanding and my research of Georgia law. And I don't have, since this is an exclusive entire agreement that between us, I have no language in my lease that says there may be times when you're living with the landlord and the landlord is reserving these spaces to himself. I had an understanding that the only part of that lease that I was not given possession or shared access to was the other bedroom. Everything else in that unit to me was shared spaces, to include the den, living room, bathrooms, laundry room,
Mr.
patio,
Brooks, forgive me for
everything.
interrupting you, but
Okay.
you're saying something I've already heard before, right? So,
Okay. Okay.
and I do need to sort of bring this hearing to a close. I do want to give you an opportunity to sort of make any final points that you would like to make.
Okay. So for me, Judge Krause, and thank you for the time to speak before you today, I am asking the court to honor and to give me the safety and security that I desire, and in my opinion, that the law requires in terms of access, in terms of just the unexpected appearance of people with keys, and you know, that sort of thing. And even when I say not a good time because maybe I have something else going on, or because of other issues like what's happening, and and I feel like all of this is retaliatory, and I really want to peacefully enjoy my home that I'm paying for every month. I'm asking for the protections, nothing extraordinary other than the law allows. And so that is my request. I have issued to you through your staff attorney proposals for what I'm asking for. And that is in a nutshell all that I'm seeking: safety, assurity in the home, and lawful access by the landlord. And I'm also asking for a service request where a service address where I can actually serve him for matters like this when we do not agree. Our situation is we do not agree. And my interpretation is not his interpretation, but I am going by what I'm reading and then my research, and then I'm asserting those rights.
I understand, Mr. Brooks. Thank you very much.
Thank you.
So let me start with the first part, which is that I don't actually have any authority to order Mr. Johnson to accept service or to provide you with a legal address for service. I will suggest to Mr. Johnson that, generally speaking, there is a procedure by which a party can ask for someone to acknowledge service, and that if they refuse to and then have to be served, there are costs associated with that, and the court has the authority to award costs to the party who has to incur them because the other side made service difficult. But beyond that, the court doesn't have any authority to order anyone to accept service or anything else. And so, Mr. Brooks, in terms of the ongoing nature of this case, after today, you will need to, take whatever reasonable steps you can to try and locate an address for service for Mr. Johnson, because the court can't order him to accept service, etc. That's number one. Number two is I appreciate the very uncomfortable and difficult nature of what you're dealing with in terms of what you're describing with people sort of coming in and out. And I only have your side because Mr. Johnson has, although he is present because he did get notice, he has declined to sort of dispute any of what you've said. But where I'm getting stuck, and I don't think I've made a secret of that, Mr. Brooks, is that I am not aware of any law that would say that an owner cannot access property that he owns simply because he has leased a portion of that property to someone else. And nothing that you've pointed me to in the lease says that the landlord does not have access. And generally, the traditional common law provisions of exclusive use and limited access by a landowner are based on the portions of the property that you've been guaranteed exclusive use of. And in this case, it's only the master bedroom. And I've not heard any complaints that the landlord has violated the one space in that unit where you have exclusive access and control under the lease, which is that bedroom. What I am hearing is perhaps impolite, inconsiderate access but access nonetheless to shared space. And nothing that I am aware of in Georgia law and nothing that I see in the lease says that an owner, Mr. Johnson, or his agents don't have access to the property. And because of that, the relief, so as you have correctly pointed out in your proposed temporary restraining order, there are really multiple things that the court looks at to determine whether or not the court should grant temporary restraining order. One is whether there's a likelihood of success on the merits. I question that again, because ultimately I'm not sure that there is a basis in Georgia law unless it's something y'all agreed to in the lease, which I don't see, that prohibits an owner from accessing property that he owns that he's not given exclusive rights or access to someone else. And what I understand to be here is that Mr. Johnson gave exclusive access to one part of the unit, but not the other part. And so beyond that, I think the larger issue I have here is that one of the things I have to find is that you lack an adequate remedy at law. And I don't think that's the case, because if in fact Mr. Johnson is in violation of Georgia law or in violation of the lease that the parties have, then that is a breach of lease agreement, and that is an adequate remedy at law that you can sue for damages or sue to enforce the terms of the lease, assuming that that is, that those terms exist in the lease. And so because of the fact that I don't believe that the plaintiff has demonstrated a likelihood of success on the merits, and I believe that, Mr. Brooks, you have an adequate remedy at law in terms of a breach of contract or breach of lease agreement claim, I'm going to decline to grant the motion that you have filed. I'm going to deny the motion. Beyond that, I do want to ask you, the petition that you filed was a petition for a TRO. And because I am not inclined to grant that, not only would I be denying your motion, but I would actually be dismissing your TRO.
Okay.
And so this action would be fully resolved. You can take whatever next steps you feel are necessary to take. And then, of course, there's the dispossessory matter that it looks like most of these issues are in front of another judge for determination of what rights of access exist in that lease and whether or not you are, in breach of the lease, or whether Mr. Johnson is in breach of the lease based on the answer that you have filed. And so that's going to be my ruling today. I understand that's not the outcome you had hoped for, but understanding that, do you have any questions? Do you understand what my ruling is? Or do you have any questions for me for clarification?
I understand what you're saying.
Okay.
I understand what you're saying. I did have a question, but it just slipped my mind. But I am understanding.
Okay.
And like we do have another hearing next week, and so I guess some of this will come up. The thing about the shared space, I've never said that I have.
Mr. Brooks, forgive me for interrupting you, but I've already ruled, and so we're not going to go back and re-argue. But also, I have other hearings that I need to get to. I've given you guys about 45 minutes, and so I really need to get to those other matters. But I'm going to enter an order that denies the motion for temporary restraining order, and then, because that was the only relief sought, dismisses the petition. And then, as I said, you can take whatever steps you need to from there, and I'll try to get that on file today, the latest Monday. Okay?
Okay. All right.
Under Georgia law governing injunctive relief, including Official Code of Georgia Annotated, Section 951, and the equitable standards applicable to temporary restraining orders, the petitioner was required to demonstrate a substantial likelihood of success on the merits, irreparable harm, and the absence of an adequate remedy at law. The court determined those elements were not satisfied. The lease at issue granted the tenant exclusive possession of the master bedroom, but not the entire condominium unit. No provision in the written lease expressly restricted the owner's access to shared or common areas. The court found no Georgia statutory or common law authority establishing that an owner forfeits access to non-exclusive portions of property merely by leasing a portion of it. The judge further concluded that any alleged improper access or breach would sound in contract and could be addressed through a breach-of-lease claim or in the pending dispossessory action. Because an adequate remedy at law existed, equitable relief was inappropriate. Accordingly, the motion for a temporary restraining order was denied, and the petition dismissed. The substantive lease interpretation and eviction issues remain subject to resolution in the separate dispossessory proceeding.